Hello, everyone. My name is Jacob Kuykendall. I'm a staff attorney for civil survival, and I'm going to be presenting tonight about some info about how to go about vacating misdemeanors. Let me get my screen shared here. Like this. So, I'm going to be presenting tonight about vacating misdemeanors. So I'm going to cover a little bit about what that is, some of the steps and some of the advice on how to do that. Done this presentation or similar presentations a number of times, but not as many times on Zoom. So I'm just going to ask everybody some grace if my sound cuts out or you hear my cat begging for food, whatever happens. It's just all part of the process. So let me talk a little bit about who are we, who's Civil Survival, who am I? Civil Survival is a nonprofit. We organize people who've been directly impacted by the criminal justice system, build connections, gain knowledge, and increase political participation. As part of that, a new part of this program is helping folks with reentry through a legal aid program to educate, share legal resources, provide education just like this presentation you're watching now. My name is Jacob Kuykendall. You see a picture of me from before the pandemic, before I grew a beard. I'm the newest staff attorney at Civil Survival, and I was hired to help expand legal aid resources to people trying to do things like waive LFOs, vacate convictions, get certificates of discharge. I did a lot of that work previously in King County and Civil Survival. Now I'm getting the opportunity to expand that work statewide. Actually, you know what I'm going to do right now? So in making this presentation, I put together a lot of resources and information. I'm going to stop this share real briefly. I'm going to paste into the chat a couple of things. So if you were watching this on Zoom, there's a link there to this PowerPoint and all the resources I used to put it together, including some forms I'm going to mention later. It's also got my email address. If you're watching on Facebook Live, that link's going to be on the last slide, so you will be able to get it along with my email address. I just wanted to share that here where, so if you're following along, you can look at some of the same slides, you can get those same access. Okay, so here's a quick overview of what I'm going to be covering. Talk a little bit about what civil survival, very briefly what civil survival is. I'm going to cover a quick disclaimer about this presentation tonight. Talk about what is vacating and expungement, what is that process, and why it can be helpful. Some of the eligibility requirements to figure out whether you are eligible to vacate something off of your record. Talking about the paperwork involved, the motions and the orders, how to set a hearing, my advice, sort of a game plan for a hearing, just a few tips about the process, other resources, and I'm going to save a good chunk of the time at the end here for questions and answers, and again, include my contact information. So here's a quick disclaimer. Please note that although practicing attorneys are presenting this workshop, this is language I've copied and pasted from a previous presentation, they're not here to give legal advice. As such, please keep any questions as general as possible. This presentation only serves to provide general legal information, does not constitute legal advice. Moreover, these attorneys will not be representing you in court or provide further services. Short version of that is, I'm an attorney, but I'm not your attorney. And I am going to save time. Well, this is a big topic. This is a complicated process, and vacating a conviction relies a lot on whatever your individual circumstances are, the individual circumstances of that conviction, what court you're in. I can't cover all of that in an hour. Probably couldn't cover that all in a day. So feel free to put your questions in the chat box. That lets us save them for later. If you put your questions in the Q&A box, we'll also be able to answer them, but they do have a possibility of getting lost. And again, try and ask questions in a general manner. I'm going to do my best to answer whatever we get. But whatever your particular situation is changes. I'll talk a little bit more about that as the presentation goes along. Vacating in Washington state is what expungement is called in a lot of other states. You'll get a lot of the same resources here in Washington, but I think it is important to know that if you call a courthouse, you talk to a clerk, you may want to try and use the word vacate, because in Washington, that's the term, that's the legal term. So what does that mean? That means getting a court order, getting a judge-signed order that will remove an eligible conviction from appearing on your criminal background checks, and more importantly, gives you the legal right to tell people, employers, landlords, you were never convicted of that crime. So what this means is the Washington State Patrol maintains a database of everyone in the state's criminal record. This is publicly accessible information. Check report for, I think it's about $12. You put in your name and your date of birth, and if you don't share that same name and date of birth with somebody else, it will give you the same report that State Patrol officers will see. That background check report from the Washington State Patrol is the same background check report that third-party background check companies, the companies that landlords and employers will use, they pull that same information from the State Patrol. If you vacate a conviction, that order goes to the State Patrol, and they basically mark that information as private. It won't be shared out to background check companies, and therefore it will be shared out to the person you're trying to get a job from. I think it's important to say this because there's a lot of stuff that vacating a record does not do. So I want to make sure the expectations are clear. It doesn't remove any court records. It doesn't delete anything. It doesn't seal anything. They're out of there. They're still out there, but they are less accessible to the general public. So if you vacate your conviction for shoplifting, when you go up and apply for a job, that shouldn't show up on the background check report they do. But if they were to go onto the Washington Court's website and search for your name and try and see if there were any court records with your name attached to it, that conviction would still be out there. That paperwork still exists in the court system. For most people, vacating a record, vacating a conviction is enough to get that job, get that apartment. But there are certain circumstances where this information is still out there. So I've talked about a couple times here. Okay, you have a conviction that you want to vacate. It would benefit you to vacate it. But I've stressed a couple times it's about eligible convictions. We're talking about misdemeanors tonight. So what is eligibility for a misdemeanor? This, again, there's a lot of rules on this, so I'm going to cover the general rules that should get you part of the way there, and I'm going to call out the parts where if you have a conviction that doesn't fit in here, there's more research, there's more thought you need to do. So number one, only certain types of convictions are eligible. Sex offenses, except for failure to register as a sex offender, are generally not eligible. Convictions, misdemeanors on your record, they will be ineligible. If you only have one, that is eligible to be removed. DUIs are not eligible. I don't think there are misdemeanor DUIs, but those aren't eligible to be vacated. And this is another one, only low severity violent offenses. I mean, that's most misdemeanors. I think if it was a serious violent offense, that'd probably be a felony, but there is some differences there. Something to keep in mind. Here's the big one that trips a lot of people up for eligibility. All your obligations have to be complete including paying off your legal financial obligations, any fines you have, in order to be eligible to vacate. Now, if you were at our webinar last night, can be waived. Certain ones can be waived, specifically things like interest or non-restitution fees. If you're eligible to have those waived, then you might be eligible to have this conviction vacated, with the caveat of this next step, which is that a number of years need to have passed since completing all your obligations. For most misdemeanors, it's going to be 3 years. If it's a DV offense, if you're one of those folks who have a single DV conviction, it's going to be 5 years for you since you've completed your obligation. So it's really important that you've paid off those fines, you've taken whatever classes you need to take, because the clock starts once you've finished all that work. Number 4 is you can't have any recent convictions or pending charges. Now, when I say recent convictions, it's that same timeline. If you have had any other convictions in the last 3 years, you're not eligible to, you're not going to be eligible to vacate. We're really trying to focus on folks who have gone a period of years without any criminal history. And if you're pending any charges, you're not going to be eligible while those are pending. Now, if charges are pending and then they're dropped, you're going to be eligible again. And if they're not dropped and you're then convicted of another crime, this is going to cause you to be ineligible for all those other reasons. This last one, which is really unfortunate, you cannot be under any active restraining orders, protection orders, anti-harassment orders, or open warrants. So I've seen a lot of folks where they're tripped up by, like, their neighbor has put an anti-harassment order against them. Unfortunately, you're not eligible to vacate anything while you're under that order. So once it expires, suddenly you can judge eligibility. Same with open warrants. So if you have an open warrant, my advice is try and get those quashed, because you're just going to be prevented from going anywhere with your vacates until those are taken care of. Okay, let me talk about motions and orders. I see that there are Q&A questions coming up, but while I'm sharing my screen, I can't look at them. So I'm going to take a look at these at any of the questions you've asked at the end, and if that means we have to go back and look at the slides again, I'll just share the screen again. So in order to vacate a conviction, you are going to need to file a motion and a declaration form. This is a single document, which is included in that link I put in the chat. You file this form requesting a court your case history to determine whether you're eligible, whether you're eligible to have this vacated, and then sign an order, which means you have to file that motion and declaration, which says, I'm eligible and here's why. And you're also going to have to file an order, a blank one for the judge to fill out. You should fill out the motion and declaration in advance before you file it. I'm going to talk a little bit about what that means here in a second. For the order, because the judge is filling that out, you're just going to be taking care of the first section, which is your name, the case number, the court. What you're going to end up doing is you will get these filed with the clerk of the same court where the case took place, where your conviction is from. So if you were convicted in Seattle Municipal Court, you're going to be filing a motion to vacate and an order in Seattle Municipal Court. You will also need to file a note for a hearing, which I'll talk about a little bit in this next slide. But again, the key here is you've got that motion and declaration form. These are provided by the state. There's a court forms website. I've included the link with the other stuff in that bit.ly link. And you're filing an order, and you may have to file a note for a hearing. So let me talk to you about scheduling a hearing and notifying a prosecutor. And I know I'm going through this pretty quick. There's a lot of stuff that isn't going to be covered in this presentation. My advice here, and kind of the way that I've structured this, because this is an hour-long presentation over a really big topic, is there are other resources that have been put together about how to go through this process, places to get these forms. I've also included those with the packet I put together for this. So I'm trying to cover basically the things that aren't in those instructions and general advice, so that I think if you read through those and you have some questions, this is going to answer some of that. It's going to give you some general strategies for being successful at following those steps. In order to have your conviction vacated, you have to schedule time for the judge to review it, which means you will need to note your motion to be heard. That's what they call scheduling these events. But judges often have set times when they hear certain types of motions, certain types of cases. This is just for their, for their efficiency. They hear a lot of cases of the same type at the same time. There might be a specific judge that hears these. So what you need to do for your case is call the clerk of that courthouse and ask for a date and time where you could set a motion to vacate. The reason that I can't give you better advice than this is, one, every court, and sometimes have different judges, handle these differently. And there's, I don't know how many different courthouses and cases and judges who might have heard your case. I'll talk a little bit about advice about this, but what you want to do is you're going to be relying on, and I rely when I do these cases on the clerk to help me out and give me the information I need. So you're going to call the clerk. You're going to say, I'm trying to file a motion to vacate. I just need to know the date and time when these could be heard next. Then you'll fill out a notice of hearing form. I included one in the materials. Sometimes the individual courts have forms that they particularly like. It's a good idea to ask the clerk, hey, what forms do I need to fill out to set this hearing? Now that you've got that date and time, you've got your motion form filled out, you've got your order form filled out, we're going to file that with the clerk of the court. The best way to find out how to do that would be to ask the clerk. A lot of courts will have you do it electronically. Some of them will do it by fax or by mail. The other twist to all of this is, with the pandemic, a lot of the courts have changed their systems and their methods for doing this in the last few months. So again, I'm not going to be able to give you good advice on that because everything's kind of in flux right now. The clerk will tell you, yes, please email it, or please mail it, or please don't mail it, depending on whatever their particular situation is. The other thing you have to do is provide a copy of all three of these documents to the prosecutor. The way that this works is, in order to set a hearing, the expectation by the court, the expectation under the law, is that you, as the person who's making this request, are doing all the legwork here. So you need to fill out the paperwork. You also need to give a copy of this paperwork to the judge, which you do by filing it. And you also need to give a copy of this paperwork to the prosecutor's office so that they can look it over before the hearing you've set, which it's also your job to set. This is a situation where, during the pandemic, I would honestly just first ask the clerk and then probably call the prosecutor's office and ask them how they're handling these, because I suspect a lot of prosecutor offices are doing these things electronically right now, and that can depend, again, which court you were sentenced in, where this is all taking place. Some prosecutors, if they are friendly towards vacating convictions, may even sign your order, agree to your order, if you ask them really nicely ahead of time and explain what your situation is. Some prosecutors will not, and will not be nice to you, and I am sorry about that, but you will have you'll have more likely to have success if you try and talk to the prosecutor ahead of time, which you're going to need to do to provide them a copy anyways. So let's say you've done that. You've filed your motion in order, you have set a hearing, you've provided a copy of all this to the prosecutor, and now you have your hearing coming up. So let me give you some just general advice from what to do at this hearing, what to do to prepare for this hearing. First of all, make sure you have a copy of all of this paperwork you've just drafted and sent off to everybody with you. A lot of times when I'm in court, a judge will say, yeah, that's great. Let me sign your order. Did you bring one? And even though I filed one with the court, they want another blank copy that they can fill out there. It's a great idea to bring copies of everything, maybe even bring an extra copy in case the prosecutor forgot to bring them or they didn't look it over, whatever. So here's my general advice. I used to do a lot of traffic ticket defense, which meant going and arguing. Usually my clients were like taxi drivers or truck drivers. And I would see a lot of people representing themselves, and I see a lot of the mistakes of folks who represent themselves they run into that I'm going to try and help you avoid. First of all, it is okay to be nervous. I'm nervous whenever I'm in court. People representing themselves are always nervous in court. The only people who are not going to be nervous are the judge and the prosecutor, who are there every day and are probably really bored by what they're seeing. For you, for me, for folks who are not in that same courthouse every day, it's totally okay to be nervous. It's expected. Second thing, this is super important. You need to be very polite and respectful to everyone in court, even if they aren't to you, and they probably won't be. I usually find that the clerks and the bailiffs are generally pretty nice and polite, but the judges sometimes aren't, the prosecutors sometimes aren't. They're tired, they're bored, they don't want to deal with you. Be very polite and respectful to them anyways, because if you're boring, they may just hustle you through and sign your paperwork. But if they don't like you, they can go out of their way to make this harder on you. And so even if they're jerks, my best advice is to just be nice to them. Step 3, if the prosecutor is supportive, that's great. It'll probably help you. If they are not, don't sweat it. The person you are trying to convince is the judge, particularly with motions to vacate. The prosecutor will say, oh, I think this person's eligible. Oh, I don't think this person's eligible. But I've definitely seen a few prosecutors say, hey, this person's eligible, but I think their record is bad. You shouldn't sign it. That's not a really good argument. The judges usually don't care that much. You are trying to convince the judge that you should have this signed. You deserve to have this signed. So they should be your focus. What the prosecutor has to say or to add helps or hurts a little, but they're not the decider here. Now, a lot of times, if you are eligible and you filled the paperwork out correctly, the judge is going to look it over and go, great, that's granted. But sometimes the judge is going to want to talk to you, or they're going to want to ask you about your motion. And I'm going to say here are the 3 things you need to focus on. And I would say from seeing a lot of people represent themselves, it helps to focus on these things and stay focused. Because a lot of times I will see folks go up there because they're nervous and they'll start talking about circumstances of why they were convicted or what's going on, why they were late to court that day. I would say, here's what you need to focus on. Number 1, you need to tell the judge what it is you want. Your Honor, Judge Smith, I'm here today. I'm asking you to vacate my conviction. Number 2, you remind the judge that the law allows this. I'm eligible to vacate this conviction. It has been 4 years since I finished paying off all my fines, so I am eligible to vacate it. And then number 3, why should the judge do it? This is where you explain why you're there in court today. Listen, I'm not able to get a job because of this conviction on my record. I've been denied renting an apartment. My circumstances have changed since I was in court last time. If you cover these 3 things, this is going to put you in the best possible place. The mistakes I see people make are to focus on other stuff, but what the judge wants to see is he can sign this order. You know, the judge can sign this order. The judge is legally able to sign this order, and they should sign this order. You're a person who should have this vacated. Now, the last thing I should say, and I want to stress, is if the judge says no because you filed your paperwork wrong, or it's the wrong date, or there's some sort of technicality, oh, you know, we didn't get the paperwork on time, don't sweat it. With motions to vacate, you can, with motions to vacate, you can always try again. These are not time limited. So if you file the paperwork wrong, you will probably end up in front of that same judge again later. So my advice would be really polite and say, oh, I'm so sorry. I'll set this on to the next calendar and I'll make sure I'll do better next time. And you go in next time, the judge will have probably forgotten that they'd ever seen you before, and it'll be fine. If they say no because they say you're ineligible, you're going to need to double check that. But usually the issues you're going to run into are paperwork stuff. You can come back and do it again. It's a hassle. I know it's trouble, but if you, as long as you're very nice and polite about it, no one's going to remember you for next time. You'll get another shot. Here's a few more tips for y'all. This is just general advice. Number one, the clerk is your new best friend. I mean, I think I stressed this before, but the clerk is the person who's behind the scenes doing all the administrative stuff at the court. So they are going to be able to find out when the next court hearing is. If they really like you or they're in a good mood, they may even say, oh, you know, the next hearing is 3 weeks from now, but oh, I see someone canceled 2 weeks from now, we can get you in sooner. They'll be able to tell you what paperwork to file and where to file it. And sometimes they'll even say, here's the prosecutor's email address, you should reach out to them. Some clerks are nice, some clerks are not nice. Some of them are having a good day, some of them are having a bad day, but they are your best friend and you should treat them like your best friend because it will help so much. That's true for attorneys, that's true for people representing themselves, that's true for the judges, across the board. Another piece of advice, file everything all at once, send everything to the prosecutor all at once, schedule them all at once. So what I mean is, you know, you've got these 3 pieces of paperwork you're filling out. You've got your motion, you've got your order, and you've got your note for hearing. Don't file those one on Monday, one on Tuesday, one on Wednesday, and then send them all to the prosecutor on Thursday. I know it's very time consuming and it's a hassle, but that is a recipe for getting the schedule all mixed up or confusing the clerk or having it show up to the judge but missing a piece of paper. File everything on the same day, send it all to the prosecutor that same day, schedule them all the same day if you can. Sometimes it's not possible, but if you can get all this information basically all done at the same time, things will be a lot smoother. If you have multiple eligible convictions in the same courthouse, in the same court, file those at the same time too. So what I mean is, let's say you have 2 convictions in Seattle Municipal Court, one from 1995 and one from 1996, different courtrooms, different case numbers. If you can file those, all that paperwork, all that stuff at the same time, often that will mean you can set them all on a single hearing date. And from the judge's point of view and the prosecutor's point of view, when they see they've got this one person with multiple cases, they're going to look through all your paperwork one time and either sign or not sign or do whatever they're going to do. If you file if you file one and then later you come back and file another one on different dates, that is going to make them do all that work twice and they might get annoyed with it, to be honest. So the best thing you can do is, even though it might require a lot more prep work on your end, do everything all at once for that same courthouse, file all your cases all at once. Here's the fourth piece of advice. It's okay to get frustrated with the process. It is a terrible, messy process, and it's meant to be hard and confusing. I find it confusing and hard, and I have done it, I don't know, 100 times at this point now. And with the pandemic having changed the process in so many places, it's a mess. And it is a process that is going to be very hard. And because it's very hard, not a lot of people file these motions. But I promise that you can get through this, you can do this. Which brings me on to my last point, which is that perseverance will be your best trait. The thing that will sink your chances of filing a motion to vacate is that the clerk doesn't return your calls, or their answers are confusing and the prosecutor's not responding by email. Keep at it, because all the work that the whole court system has pushed this process onto you, and it is tiring and annoying and exhausting and time consuming, but it will never move. Nothing will happen unless you do it. And if you keep at it, if you are eligible and you just keep hammering your head against this process, you can succeed at it. I said I mentioned this link before. I've saved a lot of time for Q&A, and I see we've got questions in the chat Q&A for me to answer. For those of you on Facebook Live, I'm going to leave this up for a minute or two. If you click that link, it should, if I've done this right, take you to a Google Drive, which includes a copy of this PowerPoint presentation, a folder with all the Washington court forms to vacate misdemeanors, and a couple of instructional guides that kind of cover the process. I'll say with those guides, they do cover the process more in depth than what I've covered here. They'll show, like, here's how you fill out the forms. But none of the guides, including my own, the one I'm giving you right now, none of them are perfect. This process is messy. Different courts handle it differently. The stuff that they've said in their guide is probably legally correct and legally true, but that doesn't mean it's going to get you all the way there in whatever municipal court you're looking at, wherever you are. So this is kind of the best I can do, is to say, here's what you need. I've put as much information as I can there. And I have also included my email address, which I'm going to put on the screen here in a minute. You're welcome to send me questions. I will try and answer those in the order I get them. I will probably respond very slowly, but I promise I will answer all the questions that I get. Folks who contact me, they go on a wait list for me to be contacted with, and I will get back to you as best I can. Oh, there's my cat. I'm going to show my email address, and then I will try to put this link up again. So I saved a lot of time here for questions. There is my email address. Wish I could put this on the screen. I will put it in the chat, but it is my name, jacob.kuykendall@defender.org. I'm going to stop this share for a second. There's me. I'm going to start with the questions in the chat, and then I'll jump over the Q&A questions. Okay. I thought that the new law made it so that the clock started ticking from completion of community custody, not when fines are paid off. Can you clarify if the waiting period starts from the day the fines are paid off? I got kind of a similar question. You know what? Let me double check. My understanding is that it starts from the completion of your obligations. But after I've answered the other questions, I will double check that for you so I make sure I'm saying this correct, and I'll answer this again. Can you put multiple case numbers on one motion, or does it have to be separate motions for each case number? Most situations, it's going to be separate motions for each case number. The only time where this is not true is if you were charged with multiple counts that had multiple case numbers. Basically, if the court consolidated these cases at some time for you, if you look at your old case paperwork and you see multiple case numbers, I've seen that maybe once out of 100 times. But generally speaking, no, unfortunately, you have to fill out the paperwork, all the paperwork for every case number each time. It's a lot of paperwork. I see Corey has posted my email and the link on Facebook, so you folks should have access to that. I have a question. How much does expungement cost versus vacating? So first of all, it doesn't cost anything, which should be a good sign. I have seen once or twice a few of these smaller municipal courts try and get money out of people. They should not do that. If that happens, please email me. But this has been an issue that has come up occasionally for small courts that probably really need the money. But no, it doesn't cost anything to vacate. The reason for that is, although you are filing a motion and an order, the case number you're filing that in is the same case that already existed, the case you got your conviction under. And as a result, you're not filing a new case. There shouldn't be any new file. There should not be a filing fee for just adding one more piece of paper onto basically the pile of your case. Now, I should clarify this question asker asked whether there is a cost for expunging versus vacating. In Washington state, there really isn't a process of expungement. There is something called expungement that the Washington State Patrol does that is basically their term for fixing a mistake in your record. That does not cost anything either, but that is not a court motion. That is a form you fill out, send it to the State Patrol, and that basically says, you wrote down that I was convicted of shoplifting on my background report, but I was never convicted, and you should correct that mistake. That is what expungement means in Washington. Otherwise, it's vacating. Vacating is what you want in order to get things off your background check. There's a question about, have you ever vacated a Class A conviction? If not, do you know of Class A felonies being vacated? Tomorrow night, I'm giving a webinar on vacating felonies, but the short answer is no. Under the current law, you cannot vacate a Class A felony, just full stop. The only thing that you can do if you have a Class A felony is, I believe, ask for some sort of pardon from the governor. I don't think that removes it from your record either. It just gives you some other legal benefits kind of similar to vacating. But unfortunately, if you have a Class A felony, this is just not going to help you. The question from on Facebook about does this only cover marijuana charges? That's actually a really good question. The answer is no. It covers any of the misdemeanors aside from the like sexual offenses and situations with multiple DV convictions. The reason I say this is a good question is there was a period in time where there was a special set of laws written in Washington State about vacating marijuana misdemeanors, and there's a lot of paperwork floating out there on the internet and even on the court forum website about the special process for vacating marijuana convictions. In my experience, at least in King County, I've never needed to use those forms for people I've helped that have misdemeanor marijuana convictions. I just use the vacating a misdemeanor paperwork, and that works much better, and the prosecutors are more familiar with it. But that is a very confusing thing out there in the world of all the paperwork. I have a question about restitution. Do I have to pay off a whole bunch of $14,000 worth of restitution before I can even think about vacating a felony? The answer is yeah, unfortunately, probably. Now, this is a question about felonies, so I'll be talking more about that tomorrow. But for felonies, you're looking at getting a certificate of discharge, and you're not going to be able to get that without having no fines left. Maybe there's stuff you can do to waive some of those fines. I'm not sure. Some of this was covered in our presentation yesterday. But this might be something where you could reach out. I would not be able to answer this question anytime soon, but I'd put you on a wait list. Take a look at your situation, because I know this is a common problem. Let me say hi to my cat who's appeared trying to interrupt this presentation. Let me take a look at the Q&A questions. Another question about the community custody. I think it's the same question. And finally, a question about, does the same process apply to felonies? It's a very similar process, but the eligibility requirements are different. It's a longer waiting period. For felonies, you need a certificate of discharge to show all your obligations are complete. I invite anybody watching tonight to join again tomorrow night when I do the presentation on felonies. It will be in felonies. But the gist of it is very similar process, very similar paperwork, but it's all a little different, and it's a longer waiting period. And I see somebody who was on last night saying the company is out of business. Well, great. Now, I'm going to answer this question live about whether the timeline starts when you have finished paying off, or whether it's when you've completed community custody. And I'm going to do that like this. Hold on a second. Share screen. So you're going to get to see some live legal work. Okay, so here is the actual state law on vacating misdemeanors. It is a mess. And it's always a pain to read, but I've read it, 1,000 times by now. So what I'm going to look at is, okay. So for a misdemeanor, in order to be eligible for anything other than described above, which means the domestic violence issues, less than 3 years have passed since the person completed the terms of the sentence, including financial obligations. Okay, so that is the situation. In order to be eligible to vacate your misdemeanor, you need to have completed all your obligations, including paying off any of your fines. So I think that's the biggest hurdle for most people. Unfortunately, a lot of people, everybody has legal financial obligations. My only thing I would suggest is if you have a misdemeanor with legal financial obligations, do look into waiving those. I have found that judges for misdemeanor convictions, if you are currently a low-income person, you're unable to make these payments. Misdemeanor convictions are, I've found, generally easier to get those fines waived. At least they're considered lower severity. So I would say start there if that's your first hurdle, and then look into vacating. But let's see here. Oh, here's a good question. Does it matter what order they are vacated if they all meet the time constraints? So as of the New Hope Act passing in 2018, no, it doesn't matter what order they're vacated. You should be able to vacate any eligible convictions you have as long as they're eligible in any order you want. I'm trying to think if there's any situation where it's, sometimes I have found that if you run into a situation, this has happened to me once or twice, where I was trying to vacate a conviction and the judge was a real jerk. Sometimes it helps to come back to them last, because then you can show, look at all these other judges, they've already signed this paperwork. You're the last one holding this up. I found that has been persuasive for me, at least. Here's a question. Somebody is asking, felony payments have to be paid in order to have misdemeanors vacated? No, I need to clarify that. So the thing you need to have paid off is all the fines associated with whatever conviction you're trying to vacate. So if you have a felony conviction for assault with $1,000 in fines left, and you have a misdemeanor conviction of shoplifting with no fines left, you can vacate that misdemeanor. You just can't vacate that felony. The two are not related. So when I was helping folks do this in the past, if somebody has 30 convictions on their record, the work for me in terms of figuring out if they're eligible, I have to look at every single conviction individually. Is conviction number 1 eligible? Has enough time passed? Did they pay off their fines? Do they have any other obligations? Oh, that one's eligible. Well, let's look at conviction number 2. No, they still owe money. That one's not eligible. Let's look at conviction number 3. It's a felony and only 2 years have passed. That one's not eligible. They're all looked at separately, with the one exception being with domestic violence misdemeanors. If you have 2 of those, neither of them are eligible. If you only have 1, it can be eligible. Let's see. What are the rules in Washington about applying for your record being vacated early if you had only a sentence for non-supervised probation for 5 years? I have never seen a judge vacate something early. There are a lot of rules, and a lot of these rules I have seen occasionally bent, but that is one that I've never seen bent. I think the general theory that the judges rely on, at least the judges I've been in front of, is that the most important thing for them is to see that you've gone a long period of time without getting any new convictions. So those timelines, those deadlines are, in my experience, pretty much ironclad, regardless of what you're sentenced to. You need to have waited 3 years or 5 years since all the obligations are completed, including community custody, including probation, everything. That is just one thing I've never seen a judge go around, I think just because they consider that sort of the most important one. Another question about the changes to the waiting time. Did this part of the bill not get passed? I can't remember well enough how it worked out that way. That's why I had to go look it up for you, but unfortunately, I think that you need to have paid off your legal financial obligations. I think that might be all the questions I have. So I think unless there's some other ones, I would say if you have other questions, again, feel free to reach out to me by my email address. I'll put that up on the screen here again, right here. Yeah, I will answer these questions in the order I receive them. So it might take me a little while to get back to you, but I am happy to answer questions. I'm happy to link you to other resources. We are in the process of setting up some more resources for folks. This is just the first step of sort of our at Civil Survival, our expansion of the legal aid we're providing. But yeah, please feel free to reach out. That's what I'm here for. That's what we're here for. And I hope you all had a good presentation. Just going to check in real quick. Corey, do you see anything else floating out there on the Facebook that I should respond to?
Nope, it looks like we got them all.
Great. Well, I invite everybody who's interested to join us again tomorrow night, where I talk about felonies. It'll be a very similar presentation, but I will cover some of the differences. And yeah, thank you so much for joining.
One more thing to add. I believe I heard to Chanel's question around when time starts. I believe there were some things that didn't get included in misdemeanors that were included in felonies. And I heard something about possibly some of those things trying to be fixed this year.
Sounds good. All right. Thanks, everyone. Hope you all have a good night, and I will see some of you tomorrow night.